Tammy in the email.
Did Chief Rodbell mention anything in that conversation about Assistant Chief Pop?
No.
Did he mention anything about Commander Minor?
No.
Did he mention anything about Lieutenant Bonnet?
No.
Thank you. One of the other issues that came up in this case involves AR 333. Are you familiar with that document?
Yes.
I have a complete copy, that first folder next to you, of your report. You included a copy of AR 333. And if you could turn to that, please.
What page is that?
If you can bear with me for 1 second, I think Sergeant Lewis can tell us, and I'm just pulling it up here.
I've got that 048 in front of me, and I copied part of AR 333 Part 2 into the first page 1, but I don't have a separate copy.
I'm sorry, so are you looking at Exhibit 1 on the bottom right-hand corner, COS-minor, and there's some numbers?
Yes, yes, sir. 002357.
Say that again?
002357.
357, thank you.
And I apologize, I think that's part of Exhibit 3, which is the Slavin investigation.
Two, 357?
Yes, sir.
If that's your investigation, I thought we were looking for any other 333.
I don't have a copy of AR 333.
Council, I think it was yesterday, we got the AR number 333 with number 5. This email, because my question about what the one that was on May 9th.
Yes.
We just use that, or
Let's see. We do have a copy. I want to ask Sergeant Lewis about the differences between the two policies and the reasons for using one or the other. And I apologize, my notes are out the window at this point, so I don't have that handy. Let's see. I know that the copy of AR 333 that was used in this case is base number 2289. Just need to find that exhibit for you. Okay, and that is part of City Exhibit 1. So, Sergeant Lewis, the thicker folder that you
Okay,
have,
it should be council. The one that's in his, in the exhibit book is actually the one that was approved May 20th, 2019.
yes.
So it was after the date of the action by Assistant Chief Slade.
Right.
But that's the one to be used. Is that correct?
That's correct, and that's what I'll be asking you about. And I don't know that he has seen, so if I could have just permission to approach with a new exhibit that we handed out this morning.
That's an interesting question. I don't want to, from the board's perspective, because we're the fact finder and everything else, the fact that Sergeant Lewis used the wrong, used a administrative regulation, which was not the one that was applicable at the time, actually raises an issue.
Well,
You know, that he did use the one that was effective at the time. Assistant Chief Slater made his statement, which goes to the question you asked. Is there any, basically, if I heard it correctly, understood it correctly, questions that have been, is there anything about the investigation that wasn't correct? Well, there's one thing already, so I'm just pointing that out, at least that's what I'm hearing.
Mr. Chair, respectfully, the issue of which version is the correct version for Sergeant Lewis to have used is witness testimony that we intend to elicit, both from Sergeant Lewis and his supervisors in the internal affairs chain of command, where they will actually be giving us fact testimony to help you as the ultimate fact finder determine whether this was in fact the correct procedure to use. So,
Okay, if the procedure is that you apply the administrative regulation that exists at the time of the investigation and not at the time of the act, that's fine. So proceed.
thank you, sir. Sergeant Lewis, do you have a copy of City's Exhibit 1, base number 2289, titled
Yep.
Administrative Regulations, AR 333?
Yes, I do.
Okay. And can you explain what this document is and why you included it in your investigation report?
So the document talks about the anti-discrimination, non-harassment policy, both Part 1 for the Title 7 protected class of employees, and then as well as general behavior of employees, and Part 2 reference the general behavior of employees and city values.
And you see that the approval date for this administrative regulation is 5/20/2019. Do you see that?
Yes, I do.
Can you explain the process by which you got a copy of this to use in your investigation?
When I get assigned an investigation, in this case, I went on to our shared drive, SharePoint, I think it's called, and I downloaded a copy of it.
Did anyone in the department direct you to use the 2019 version of the AR?
No,
Have you had a chance to review the previous version of AR 33?
I have not looked at the previous version.
Okay. And for the record, the approval date of that is July 17th, 2003. Do you have any understanding of what changed in between the two ARs?
I think it was a...
Objection, foundation. I think the witness, if I recall, just testified that he hasn't seen it. How would he know the difference if he hasn't seen
I'm
it?
sorry, you're going to have to speak up.
I'm sorry, my objection is foundation. If I heard right, and I might have heard wrong, the witness just testified that he hasn't seen the policies, so how would he know the difference if he hadn't seen it?
Council, at some point in the future, if you want to make a presentation side by side, just explain to the panel that information, that's fine. Again, we can do those things. We're not in the court of law, we're not subject to the rules of evidence.
My specific objection was that this witness, I think, I might not have heard, so if I didn't hear, that's a different story. But I think this witness just testified that he'd never seen the old policy, which means he has no foundation to testify about the differences.
Right, but have you compared the two policies, sir?
I haven't compared them, I've used the old one in investigations before.
Well, so I think, counsel, we move things along, if there are specific differences, you just tell the board what those differences are. I mean, maybe no differences, but I want to make clear, I try to be transparent. The fact that he used a document that did not exist, even if it was the same document, there was no change, they corrected a typo. That is material, or that's relevant, and I suppose it's arguably material. It may not be much weight if they're both exactly the same, but that's a fact that exists.
Sergeant Lewis, what was the date that you commenced your investigation into Assistant Chief Slavin?
June 27th, 2019.
5 weeks after the approval date of the copy of AR 33 that you used for your
That's
investigation?
right.
And I believe your testimony is that no one in the department directed you to use any particular version of the policy, is that right?
Correct.
You made a number of conclusions conclusions in your investigation as to Chief Slavin? Just to orient you to that. You have a copy of your investigation report in front of you for the Slavin Internal Affairs investigation.
Yes, and that's number 2357.
And you, in coming to your conclusions, found that there was a violation of AR 333 Part 2, is that right?
That's what I sustained, yes.
Can you explain for me why you sustained a violation of Part 2 and not Part 1?
Because during my interviews, everybody said, there are people that remember hearing something from Chief Slavin that it was done in a joking manner. That I asked Commander Minor if it was harassment, he said no. If it was a cutting remark, he said no. And that no one from that protected class that I know was in that meeting.
Is protected class membership a significant difference when you are investigating these types of complaints?
Yes, it is.
Isn't it true that there are examples of previous internal affairs investigations where a member of a protected class was subject to a demeaning joke comment, and yet the AR 333 violation was sustained as a Part 2 instead of a Part 1?
Yes.
Can you explain?
Counsel, I think this is getting into some serious issues here. Is it the contention of the city that if someone makes a sexist statement, a statement questioning someone's sexuality, it's not subject to Part 1? If everyone thinks it's a joke, there's no one who's the target of it, apologize to anyone in this room, whether African American or not, to use the N-word if everyone's standing around this way, they don't care. Is that the position of the city?
Well,
As a matter of law, that is not creation of a hostile environment or harassment?
okay. Well, I think that's an interesting question because, first of all, the overall purpose of the hearing is to talk about whether the city followed its usual pattern and practice, or whether Commander Minor was singled out, or, you know, as part of that, whether Assistant Chief Slavin was singled out for some kind of preferential treatment. And so part of the city's usual policy and practice and how it's been interpreted in the past is relevant on that issue of, does internal affairs treat these investigations the same way? The city does have a anti-discrimination and anti-harassment policy. I do think as a matter of law that there is not an equivalence between something that is unquestionably derogatory, like the N-word or like something like that, versus the word gay in and of itself is not an insult. It was not